City Club of Portland's Friday Forum. I'm Steve Novick, a member of the City Club's Forum Board. For more than a century, City Club of Portland is where civic-minded people work together to make Portland and Oregon a better place for everyone to live and explore. We're gathered today at the Sentinel Hotel and are joined by thousands of Oregonians via X-Ray FM's radio station, KGW's website, Facebook feed, and news app, and Open Signal's community media television stations. In addition to the City Club's valued media partners, our volunteers and staff enable us to continue to put on the state's best civic programs week after week. Please join me in showing our appreciation to everyone who's made this event possible. Joining us today is Ellen Rosenblum, Oregon's Attorney General. A former federal prosecutor and state trial and appellate judge, Ellen Rosenblum is Oregon's 17th Attorney General and the first woman to serve in this position. Her office, the Oregon Department of Justice, works on many issues including consumer protection, internet privacy, student debt, civil rights, elder abuse, and crimes against children. Attorney General Rosenblum has been active in local and national organizations of lawyers, judges, and attorneys general. She served on the executive committee of the National Association of Attorneys General. She's the immediate past chair of the Conference of Western Attorneys General. She served as secretary of the American Bar Association and is the chair of the ABA section of state and local government law. She co-founded the section's Attorneys General and Department of Justice Issues Committee. Attorney General Rosenblum is a proud duck with both her bachelor's and law degrees from the University of Oregon. But as a judge and as Attorney General, she has dispensed justice even-handedly to beavers, Vikings, ducks, raiders, and mountaineers alike. I am particularly looking forward to this forum because it is my impression that of all the elected officials in Oregon, Ellen Rosenblum is having the most fun. I get a lot of emails from a lot of politicians, and many of them these days are pretty downbeat. Hers are not. She clearly enjoys her job. And I have to say that I have a sneaking suspicion that she especially enjoys suing Donald Trump. Please welcome Ellen Rosenblum.
Thank you, Steve. That was a wonderful introduction. I truly appreciate it. Thank you, Lisa, for a fantastic year. Congratulations. Welcome and all the best to Colin for your year ahead. Thank you to Julia and the staff and to all of you for having me here today. I really appreciate the opportunity to visit with you. And that's because for generations, this City Club has been a thought leader for Portland and as a consequence for Oregon. And it's important for all Oregonians to know what I, as your state attorney general, am up to, especially when it comes to protecting the rights of everyone who lives in our beautiful state. And yes, I am having fun. To begin, let me provide a little context. From the moment I first ran for this office in 2012, I said I wanted to do two things as your attorney general. First, I want to have the Department of Justice perform our statutory duties to the best of our abilities, that is, to provide the gold standard of legal advice and counsel to the various state agencies who rely on our guidance. That's a crucial function of our office and is our primary reason for being, to help ensure the wheels of justice turn smoothly for all who come in contact with our government. As a part of this role, we have an entire division devoted to defending the state in lawsuits brought against it. And we handle every criminal appeal throughout the state through our appellate division. We also help any district attorney or local law enforcement agency with their investigations and cases when they request our assistance. Second, I promised to serve as the people's attorney general, looking out for all Oregonians, especially those who are most vulnerable. That means paying special attention to the consumer rights and civil rights of the young and older adults, minorities and immigrants, crime victims and survivors, and even students who as adults are often left saddled with education-related debt. This latter goal of being the people's attorney is why, for example, we've worked so hard to prevent police profiling, why I just announced that we are leading a hate crimes task force, why we started a statewide elder abuse unit and conduct scam jams for seniors all over the state, why we worry about privacy in the digital age and openness of public records, and why we go after pharmaceutical companies that harm or cheat our people. It's also why we find ourselves engaging so strenuously with the current federal administration. You've titled today's remarks, Suing Trump, AG Ellen Rosenblum on Oregon's role on the national stage. But I don't start with the notion that it's our job to sue the president. In fact, this may surprise you, but the thought had not really crossed my mind that I would spend a good part of my second term as Attorney General suing the president. Rather, my concern and the concern of my office always is with enforcing the law and protecting Oregonians. And it is through this lens that we make decisions about when and whether to get involved in legal matters of national significance. With every matter that comes before us in the realm of my work as the people's attorney, the first question I ask is pretty straightforward. What impact does this have on the people of our state? Does it threaten physical or financial harm? Does it intrude on their rights? If any of the answers is yes, the next question I ask is equally straightforward. Does the rule of law offer us an opportunity to protect our people from these harms? That is there a constitutional, statutory, or due process violation? Of course, it is important always to consider resources and to determine whether there are possibly other avenues for redress. But if all of these boxes are checked, then we engage. When it comes to matters of national importance, my office can act on its own, but most of the time we join with other states, because that's the best way to get the most out of our relatively limited resources. I think you'd be surprised to know how much we do in a truly bipartisan, multi-state fashion. In fact, we attorneys general have been doing this in the consumer protection arena for decades, most famously with the National Tobacco Settlement in the 1990s. To give you an idea of some of the larger bipartisan issues of today, take these two, for example, opioids and privacy. Privacy and its invasion, think Equifax, just for starters, knows no partisan bounds. The number of data breaches and the amount of people's personal information affected is simply staggering, and Oregonians have not been spared. The recent Facebook letter that I spearheaded with 3 other state AGs, 1 Democrat and 2 Republicans, demanding answers to questions about the Cambridge Analytica fiasco, had no less than 41 state attorney general signatories. As for opioids, the harm they cause affects people of every background and persuasion. Dealing with abuses by big pharmaceutical firms happens to be an area of special legal expertise for our office. So both Republican and Democratic AGs requested our involvement in the multi-state settlement discussions that are now occurring with a Cleveland federal judge. Even the federal government has asked to join in these discussions, finally. So we are not always suing Trump, as you describe it, and we are not always divided by party affiliation. In those cases where we take the lead, we have real expertise, and Oregonians' lives are impacted. Now, I know you're interested in where our office gets into it directly with the Trump administration. So, to give you an idea of our specific work on behalf of Oregon, as of today, since January 2017, I have joined 15 lawsuits against the federal administration. I have joined, but wait. I have joined 45 environmental actions related most often to environmental protection rule rollbacks or to enforce the Clean Air or Clean Water Acts. I have also joined 41 amicus briefs, or friend of the court briefs, as they are known, in cases across the country where Oregon is not a party directly to the lawsuit, but we wish to provide support for a legal theory or issue that could affect our court's rulings in the future. All of these are matters where we have determined, based on the process I just laid out for you a few moments ago, that we simply must look out for our own. The courts in various parts of the country are home to many of our current battles. Recently, I was asked whether the courts are a new place for these battles. They are not. Courts are traditionally and appropriately the place to seek fairness and justice and equal protection for all people under the law. What is new is that our own president is seeking to take those basic freedoms away from the very people whose Constitution he has sworn to protect. And that is why we must use the rule of law as a shield to protect Oregonians. So let's begin where this all began, in January of 2017 with the travel ban. Actually, a group of us Democratic AGs had gathered at one of our quarterly conferences when that fateful executive order was issued. It was a Friday afternoon. By Monday morning, the first lawsuit was filed by Washington Attorney General Bob Ferguson. Swords were drawn. And because of this continuous barrage of illegal actions stemming from Washington, D.C., they have not to date been sheathed. That executive order, number 13769, was not even thinly veiled religious discrimination. It was intended to ban Muslims from entering our country. After review, we determined it to be plainly unconstitutional. At the same time, we had to determine whether Oregon had standing. That is, had we been harmed? The clear answer was yes. The ban prevented Muslims from entering or remaining in the United States, even for professional or academic reasons. So, in filing our court documents, we included statements from universities, OHSU among them, about students who were unable to return to Oregon for school or residency programs, and without whom our investment in their education would not be realized. In addition, we noted that many rural areas in Oregon rely upon foreign-born doctors for basic medical services. That is why I joined the state of Washington's lawsuit as a plaintiff and subsequently supported Hawaii's successful challenge to the ban through an amicus brief. Our combined state AG actions forced the administration to revise its ban 3 times. We now await the United States Supreme Court's decision, likely later this month. Whatever the outcome, I believe our actions have, at a minimum, served to soften some of the vicious impact intended by the president and the harm his bans would do to America as a whole and Oregon in particular. The next major case we joined involved the program called Deferred Action for Childhood Arrivals, or DACA. The president seems to have no end to efforts to insult and instill fear in our immigrant communities. That is why, as soon as he indicated his intent to dismantle DACA, we sued in support of Oregon's Dreamers, challenging the rescission of DACA. Again, lawyers in my office gathered declarations and prepared a statement of interest on behalf of the state of Oregon as a plaintiff in the lawsuit against the federal administration. 3 of the most articulate, intelligent, and passionate young DACA recipients came to our offices for help in preparing their affidavits, which were attached to the filings. I felt that bringing the lawsuit was necessary to protect the interests of our state, which is enriched by the DACA program and these exceptional young people. That's because more than 11,000 DACA recipients have come forward, passed background checks, received permission to live, work, and go to school legally right here in Oregon. And if this program ends, more than 10,000 highly educated, motivated, tax-paying, contributing members of our society will no longer have legal status, even though most of them know no other home and have lived here longer than many transplanted Oregonians, maybe even some of you. So far, with the help of federal courts on both the East and West Coasts, we have succeeded in keeping the program alive, though possibly only on life support, unless and until Congress acts. Also in the immigration arena, we requested records about detainers and immigration actions from ICE and the Department of Homeland Security. These detainers and other actions occurred right here in Oregon. And guess what? ICE and Homeland Security simply did not respond. To hold them accountable under the Freedom of Information Act, we sued to require them to turn over these records. They finally did agree to do so, but only at the rate of 500 pages every month. Our review has only recently begun, but perhaps to no one's surprise, we have already identified plenty of instances where immigration officials crossed the line. In fact, records reveal emails between officials giving high fives all around for managing to circumvent the sensitive location designation of hospitals by detaining a person as he came out the hospital door. Let me next pivot to healthcare and the ACA. We are challenging the rollbacks of ACA subsidies that take away healthcare from middle-class Oregonians. Recently, we intervened in a case to defend the ACA from attacks by a group of states, led by Texas, who are seeking to have it declared unconstitutional on the basis, yes, really, that the new tax reform law requires it. I firmly believe it is important for us to stand up for the ACA because an adverse ruling could dramatically impact health care for all Oregonians. In a directly related matter, I continue to speak out in support of women's health care and reproductive rights. Wednesday, I attended the Courageous Voices Breakfast of Planned Parenthood, and that night, an event in support of NARAL. It is no accident that Oregon is the only state left standing with no restrictions on abortion. So this week, when the Trump administration continued its attacks on women's health by issuing a gag rule seeking to prevent healthcare providers who offer abortion services or referrals from participating in Title X funded programs, we immediately leapt into action. The administration's gag rule is just the latest in a series of attacks on access to health care in America. Instead of expanding access to preventive care, cancer screenings, STD testing, birth control, and family planning services, it seems the administration is once again turning back the clock, trying to tell women what they can and can't do with their bodies. My office will fight tooth and nail to protect a woman's constitutional right to make decisions about her own reproductive health. Now, I know this list seems long, but it is only a fraction of the different ways the administration has begun to cut away at the rights of Oregonians. Just this morning, 3 national civil rights groups are reported to have sued Betsy DeVos for the Federal Department of Education's new procedures that allow its Office of Civil Rights to dismiss complaints that it determines to be burdensome or a drain on the department's resources, with no right of appeal, of course. So, next on my list of 15 pertains to the United States Census, which is to be conducted, of course, in 2020. I think we can all agree that the taking of an accurate census every 10 years is one of the most important requirements embedded in our Constitution. The guarantees of a representative government come from having an accurate count of those represented and knowing that our voice will be heard based on equal representation in Congress. Other important decisions flow from the census information, including how much funding is needed for various government programs, infrastructure, health care, benefits and subsidies, just to name a few. So you may have heard that the Commerce Secretary and the President decided to include a question about citizenship in the 2020 census. So together with 17 other attorneys general, I joined a lawsuit against the Commerce Secretary and the administration. We believe adding this question is a violation of the United States Constitution's enumeration clause. Go read it. That's because the question will have a chilling effect on census participation and will result in an inaccurate count of the people in Oregon and throughout the United States. When it comes to our precious environment, people all over Oregon are speaking out against the administration's actions. Our state's natural beauty, wildlife, and landscape are among its greatest treasures. We are listening. As I noted earlier, we have taken over 45 legal or administrative actions, often in the form of sign-on letters and formal comments, and we have filed several lawsuits challenging Scott Pruitt and Ryan Zinke, among others, for their reckless disregard for the protection of our planet. Most recently, we sued the EPA for failing to control methane pollution by unreasonably delaying its mandatory obligation under the Clean Air Act to control methane emissions from existing oil and gas operations. We also sued the EPA and the Army Corps of Engineers to block unlawful delay of the Clean Water Rule. We argued that the EPA ignored scientific evidence and a multi-year comment process when it changed the definition of waters of the United States. Thanks to litigation during the Bush era, we already have authority and standing to states to require the federal government to control greenhouse gas pollution under the Clean Air Act. We also have a team examining our legal options to protect the Cascade-Siskiyou National Monument in Southern Oregon. Interior Secretary Zinke's recommendations to the President to rescind the national monument designation, either in full or in part, have us examining the harm this possible action will cause Oregon. So final decisions haven't been made yet on that, but we are working on that in the event that that does happen. No surprise to any of us here, I'm sure, there's another area of conflict with the current federal administration: cannabis. Since the legalization of marijuana in Oregon, we have helped state agencies create rules and regulations that support the development of a robust new industry. But the 2016 presidential election and the appointment in particular of Jeff Sessions as United States Attorney General have rolled back some of the very reasonable policies that came about during the Obama administration. And one of these was the rescission of what is referred to as the Cole Memo, basically an agreement by the federal government not to enforce or prosecute under federal law for marijuana activity within the states where it has been partially or fully, as in Oregon, legalized, with some restrictions and limitations. I plan to work with United States Attorney Billy Williams to minimize the effect of this new policy direction on our industry and still strive to comply with the spirit of the original Cole Memo. I was not able to attend the U.S. Attorney's appearance here last week, but I understand that he has new guidance, and I support his efforts regarding illegal diversion of marijuana out of state. Cannabis, as I have said, is a major emerging industry here. I both support it and continue to work with many others to ensure its safety and its effective regulation. So don't get me started on the crazy banking regulations the feds insist on with regard to this industry. It is not very realistic to have a lawful business model where there is no legally sanctioned, secure place to put the cash obtained through that business. So all I can tell you is that we're working on it. But it will take federal action, and that could be a long time coming to truly make it work. Although some have had some good ideas about starting our own state bank. So we can talk about that later. I cannot leave you without a more in-depth mention of the scourge of student debt. Education-related debt, now at $1.4 trillion nationally, has been one of my key initiatives throughout my time as Attorney General. And it's not only because I have 2 children in their early 30s. It's what I call the obligation of a lifetime, because it is a type of debt that is rarely dischargeable in bankruptcy and follows people to their last dying breath. Until recently, we had the support of both the Federal Consumer Financial Protection Bureau, also known as the CFPB, which has had a robust student loan ombudsman program, and the United States Department of Education, which had rules ready to roll that are now being rolled back. Now, though there are still some exceptional folks hanging on at the CFPB, it feels like we are more and more on our own to address this terrible situation. 2 of our 15 lawsuits have to do with this subject. I have partnered with colleagues to file a lawsuit against Secretary Betsy DeVos for delaying the implementation of rules designed to crack down on for-profit colleges that engage in deceptive practices. These rules would have protected students and allowed many of them to have their loans forgiven. We also sued the Department of Education, DeVos, for failing to implement a rule that requires for-profit colleges to help students find gainful employment after they graduate. This is what I call the Trump University rule, and it is no surprise that DeVos is siding with her boss on this one. 33% of all federal student loan defaults are by students who attend for-profit schools, institutions which take virtually no responsibility for their students' success in finding jobs. And where there's money and vulnerable consumers, we know there are always scammers lurking. Oregonians owe $18.5 billion of that number I gave you, $1.4 trillion, in student loans. And $2 billion of that is delinquent. But rather than being able to turn to the CFPB for support to get rid of scam debt relief companies that prey upon unsuspecting new graduates, its new leader, Mick Mulvaney, you know that name, recently axed his highly regarded Student Services Office. Our Consumer Protection section at Oregon DOJ is seeking to pick up the slack. We have already shut down 4 of the worst offenders, And we're cautioning student debt obligors not to fall for the solicitations of these companies that will take their money and offer no real help. There's another way to fight the Trump administration's harmful approach to governing, through state legislation. In Oregon, we have had good success in this regard, partnering with legislators to fill in some of the gaps. For example, in the area of student debt, I spearheaded a new law that requires colleges and universities to inform students in an easy-to-read format and on an annual basis how much federal debt they have incurred and what their approximate loan payments will be for that debt when the time comes to begin paying it off. Simple piece of legislation that will hopefully be very helpful to our students. Thank you, students, by the way, for being here with us today. Yay. and to your families. And when it comes to gun violence, Oregon is ahead of the curve with our new Extreme Risk Protection Order, or red flag law. There are 8 states now that have this law. This law allows a person to petition the court for an order removing guns and other weapons from people who are a danger to themselves or others. Just this morning in the Huffington Post, an article noted the effectiveness of these laws in reducing suicide. If used, they also have the potential to prevent a school shooting. After each of these horrible school shootings, we ask ourselves, what can we do? Certainly, thoughts and prayers are no longer enough. As I traveled the state, I realized that most Oregonians do not know about this relatively new law, also known as the red flag law. So my office just created a one-pager that we have for you here today that spells out how it works. And so I hope you'll take a copy, or you can also go online to OregonAttorneyGeneral.gov to download this one-pager. It will be worth it if together we can save just one life. And I'm very proud that our governor and that so many of you are also working, and our legislators are working on other anti-gun violence legislation, and I look forward to working with you. It's a it's my top priority, so please let me know how I can help you the most. We're listening to you, students. We also sought passage of an updated data breach law in the Oregon legislature designed to create stronger protections for Oregonians in the event of another massive data breach like Equifax last summer. A federal investigation of Equifax appears to have stalled. Big surprise there, right? So again, where this administration fails to act, the states must step in with tools that protect our people. So Oregon's new data breach law requires companies to freeze your credit upon request free of charge. It also requires companies who experience a breach to tell consumers about it within 45 days of the breach, instead of allowing consumers' information to be accessible for months before they even know that it's been compromised. This bill will not prevent data breaches altogether, but it will better protect you after a breach has occurred. In addition to joining a lawsuit to undo the repeal by the FCC of its net neutrality rule, my office helped draft and support a bill here in Oregon that would at least partially negate the FCC, that's the Federal Communications Commission's regressive actions here in Oregon. So until very recently, the internet operated freely and openly. But all that changed last December when the FCC reversed net neutrality protections, making it possible for the big service providers to prioritize certain consumers and to slow internet traffic on the basis of its content or source. So basically, our new law prohibits public bodies from contracting for internet services with providers who are not in compliance with the general principles of net neutrality. So if we win our case, or if the U.S. House joins the U.S. Senate in undoing the repeal, we could actually get back to nationwide net neutrality. In the meantime, I believe that Oregon's new law is one small way we can level the playing field for our smaller businesses, entrepreneurs, and consumers. Also in the 2017 legislative session, we worked on the issue of police profiling, a topic that I know many of you care deeply about, as do I. As a result of a task force my office led, we supported the passage of a law that requires collection of police, vehicle, and pedestrian stop data, and training of all officers on prohibited profiling. While I can't tell you this law was in any way intended to address the horrors related to the current immigration crackdowns, it turns out to be yet another tool with which to fight injustice. Under Oregon law, it is now illegal for a law enforcement officer to stop someone based solely upon the officer's perception of the person's age, race, ethnicity, color, national origin, language, gender identity, sexual orientation, political affiliation, religion, homelessness, or disability. At a time when there is increased pressure from federal immigration authorities to detain people based upon their appearance or language, here in Oregon, profiling based on an officer's perception is prohibited. And we now have laws in place to help to ensure that our law has teeth. Let me wrap this up, so we'll have time for your good questions and comments. As a judge for many years, and your Attorney General for the past 6, it's in my DNA to turn to justice and the rule of law as a shield against oppression and a banner for fairness and equality in the face of threats to the sovereignty and well-being of Oregonians. When the administration, the federal government, does things that are unconstitutional or otherwise illegal and that adversely affect Oregonians, we have to try to stop it. I had no particular craving to land us on the national stage, but in fact, each of these actions we've taken locally is designed to preserve and protect Oregon. I act on the premise that we aspire to live in a state that is safe, welcoming, diverse, inclusive, and thriving, both in terms of our people and our environment. We want our children not to be saddled with debt as they grow older and start families of their own. We want smart, passionate young immigrants to feel safe and valued and not ever to have to live in fear. We want the air we breathe, the water we drink, and the land we walk to be clean and safe. We want our planet to survive. We want sick and healthy people to be able to access quality health care. All people, not just those who can afford it. Is this too much to ask? Of course not. But we cannot assume these things will be here for our children or even for us if we fail to act when the rule of law is violated. So that's what I'm doing and why I'm doing it. It is both a great challenge and a great honor to be the chief law officer of our wonderful state of Oregon. So thank you for giving me an important and thoughtful forum in which to discuss these profoundly important matters.
Thank you so much. For our radio audience, this is City Club of Portland's Friday Forum. I'm Colin Jones, president of City Club, and we've been hearing from Oregon's Attorney General Ellen Rosenblum. We'll now go to questions from the audience. If you've written a question on an index card, hold it high for City Club staff to collect. You can also submit questions via Twitter using the hashtag FridayForum. To City Club members who would like to ask a question at the microphone, please identify yourself as a member and ask one question in 30 seconds or less. Well, let's take the first question.
Anthony Petchel, City Club member with Reach Community Development. One of the things that we're seeing is the administration essentially not enforcing current rules. One of the ones that is on our radar is HUD is essentially not enforcing fair housing laws and the reporting that is required under that. Can you maybe talk to how you're keeping abreast of what things the administration is choosing not to actually enforce?
Thank you for that question. In particular, with respect to housing, of course, our Bureau of Labor and Industries has the primary responsibility for housing issues that we then take up in litigation if we are requested to do so. So I would actually need to check with my folks to see if there's been an uptick in the cases that we've been asked to handle. I don't believe that there has been, and very possibly for that reason. So happy to thank you for the question, and particularly to pointing to that particular area. Every day When we wake up in the morning, we check our Twitter feed, we check for executive orders, we check for rule rollbacks. It's a little bit harder to check for the rules that just simply aren't being enforced, but we can tell when there are people in charge of agencies that are there because, in part, they indicated previous to their appointment that they actually didn't believe in the work of that particular agency. So take the Department of Education, take the Environmental Protection Agency, just about every agency. It seems as though enforcement has just kind of either slowed down or come to a complete standstill. I can give you one specific example is student debt. I'm well aware, because Mick Mulvaney has told us that he is substantially cutting back on enforcement of rules and that he'll be focused more on allowing the states to do what they wish to do in this regard. Well, of course, that means we have to step it up, and that's what we're doing. But there's lots of states where that's not happening, and I have grave concerns for the students, for example, in those states. So we're doing what we can.
We have one question from Twitter. You spoke to your work holding corporate bad actors accountable, and several of those companies, including Facebook, banks, and pharmaceutical companies, have been donors to your campaigns. How do you balance the interest of your donors with your goals as the people's attorney?
Well, I will say this, that there's no pay to play in my world. We do have to run campaigns, and so we do accept contributions, and I have not prohibited corporate contributions, but I've made it very clear that when I meet with any company that there's absolutely no nothing special that they get because they may have contributed to my campaign. And I will say that I also try to keep those campaign contributions fairly minimal so that there's not a sense that I'm indebted in any way or beholden to that corporation.
Thank you.
Excuse me, Kathy Moyd, member of the City Club. First, I want to thank you for all the work you and Kate Brown have been doing with respect to climate change. But there's another issue that I'm concerned about that hasn't received nearly as much publicity, and that's the separation of church and state. That a lot of the actions that are going on at the federal level, both Congress and the executive, are, I believe, crossing the line, both with respect to preferring one religion and denigrating those of us who are not religious at all. And I'm wondering, what, if anything, have you and the other state attorney generals been doing on this issue?
Well, of course, I talked about the travel ban and our belief that that was essentially a Muslim ban, and so I think we've taken that up. We've also been involved anytime there is a case that involves an attack on women's reproductive freedoms where religion seems to come into play. We have taken the position that the constitutional rights of women trump any religious preference in that regard. So I guess I would just have to tell you that we're very aware of the issue, and as matters come to us, we certainly evaluate them, and we've taken on a number of different cases involving that question. I do believe in the separation of church and state, just to clarify. Thank you.
Ted Kay, City Club member. I believe your offices have been involved in investigating alleged inappropriate behavior by both a mayor of Portland and a governor of the state. Would you comment on what that's been like?
Comment on what?
On having to be involved in investigations about behaviors of the mayor of Portland and the governor of the state.
Well, you know, that really hasn't been a major focus of our attention. The governor investigation primarily was a federal investigation, and so it was one that I was asked to essentially stand down and defer to the feds, which I did. And that, you know how that one ended. So, you know, here's the thing. It's my job to investigate public corruption if I'm requested to do so. And so that's part of what we do. We do it every day. We look into whether it's a city councilor or a county commissioner or a dog catcher. Could be the mayor, could be the governor, which obviously is a lot more high profile. But that's what we do. It's a statutory obligation, and I take it very seriously.
We'll take a question from a note card. The current Secretary of State has allowed signatures to be gathered before initiative language is finalized, and this has withstood some legal challenges. Do you have an opinion on this, and is your office doing anything to protect the initiative process?
Well, we're very involved in the initiative process.
Yes.
As you probably know, we draft the ballot titles. And so you don't actually find me. It's a little bit awkward for me. And in some ways, I wish that I didn't exactly ask for this job, as that part of the job anyway, of drafting ballot titles, because it means that I kind of put on my quasi-judicial role, and I don't take positions on ballot titles. But I'm very concerned about the process, and I think it's very important to have a well-written ballot title that we know is going to go to the voters, that they will understand, and they will be, that it's neutral, not only well-written, but that it's neutral and fair, and hopefully easy to understand. So it's a little bit strange, the concept of getting signatures before we have a finalized ballot title, and that is not what we're doing at this point. That has not been approved. So there's still, you have to get a certain number of signatures to even get it to the point of requesting the title, right? So I don't think that's what you're talking about. It's after that, and I know that Secretary of State Richardson had requested that, but that has not gone into effect. You still have to have the title. You still have to have the caption and the title before you can gather the signatures, as of now. And I hope it stays that way.
Thank you.
Mark Rarick, City Club member. I'm a retired oncologist and quite involved in patients' right to choose in the end of their life. Recently, there's a California court that apparently put that law on hold. Do you know if there's any other court dealings in Oregon that potentially would put the jeopardy of our death with dignity law?
I am not aware of any. I'm a supporter of that law, and as you know, we went through a lot of legal processes. In fact, it even went before the voters 2 times, because I guess the first time some didn't think that we meant it. I certainly, if I have not heard of that in Oregon, but if it does come up, I would assure you that I would support our law as it is written. And I think it's been effective. I don't think it has been abused in any way.
Anoa Edian, City Club member. Thank you for your work. The change in laws around the legalization of marijuana means that there are currently a number of people incarcerated who are there for criminal activities that are no longer criminal. We know that both nationally and in the state of Oregon, this disproportionately affects Black and brown citizens. I'm wondering if you can speak to any actions in your office or that you may know of in other states that are dealing with similar things to review and address these sentences of people who are serving time for things that are no longer illegal. Thank you.
Thank you for that question. I know that that is something that is being done around the country. I will say this, I'm not aware of any particular move here, and if there is one, I'd stand corrected, and happily so. But I will say this, that I think in Oregon, you're not going to find that there are people in prison who are there for exclusively the use of marijuana. If there are, then I will personally take on the responsibility to point that out and try to get something done about it. Those who are in prison in our state are simply not there for that reason. And that's one reason why I think when we worked on justice reinvestment a few years ago and we analyzed what was going on in different states, some said, why don't you look to Texas? It looks like Texas is releasing way more people from their prisons than we are here in Oregon. And I said, absolutely. That's the reason that they are, is that they've been imprisoning people in Texas for possession of marijuana, and that's not what we do here in Oregon as a general matter. And I'm not saying that there have not been some cases where that has happened. And I'm also not talking about federal, because my responsibility is for state matters. And so it may be that I stand corrected as to the federal prisons in Oregon. But as to the state, I am reasonably confident at this point that that is not a situation that we need to address in any major way.
We have a note card question on a similar vein. Do you have any interest, or your office any interest, in the expungement of nonviolent cannabis cases and records?
Well, there's an expungement law in Oregon, which I've certainly, anyone is entitled to use. And I'm trying to think about whether there would be an exception of any kind for cannabis. I don't think so. So I believe that if they qualify for expungement, certainly I would have no problem at all. If the expungement law perhaps should be expanded, or there should be a special section in light of the legalization of marijuana, I'd be happy to take a look at that. Keep in mind that in Oregon, we've had essentially decriminalized marijuana since the early 1970s. Does everybody know that? So that's another reason why we really haven't had as significant a problem with marijuana exclusively as other states have had. It has not been a crime in Oregon since 1973 to possess less than an ounce of marijuana.
Thank you.
Hi, thank you very much. Excuse me, I'm sorry. Penny Okamoto, I'm the Executive Director of CSFI Oregon Education Foundation, and we're a City Club member. I'm asking you today about some petitions that have, the petitions that are called Second Amendment Protection petitions. We call them SAPs, and they have been issued throughout the state of Oregon, Deschutes County. It was recently turned back in Harney County. But these so-called Second Amendment protection petitions, or SAPs, would actually give the county sheriff the right to interpret the Second, Fourth, and 10th Amendment of the United States Constitution, and also allow the county sheriff to not enforce firearm laws within that particular county. Of course, we have great concern about this. We know that an ordinance was passed in 2016, I believe, in Coos County, and I was wondering if your office is taking any action about these. Thank you.
Thank you for bringing that to my attention. I was aware of them, but I don't believe at this point it's been brought to our attention to take action. Of course, it's possible that we could be asked for some legal guidance by state agencies or by the legislature. There could potentially be a preemption issue there. I would think, perhaps if you're not familiar with that concept, what that means is if there's state law essentially, I hate to use the word, but trumps local law, just like federal law can trump state law. And that actually is a big issue right now at the federal level, because a lot of these federal agencies would like to do that with just about everything they do, even though they want us to enforce the law. So go figure. I will look into that and find out whether we are doing anything. I don't mean to be avoiding the question, but I'm not aware that we are.
On the topic of preemption, we have a question that says, current state law forbids local jurisdictions from enacting laws that place restrictions on firearms. Has there been any discussion about possible modifications of this preemption law, and would you support such an effort? I think fundamentally to allow local jurisdictions to limit firearms.
Right. Again, I think that is a kind of a pretty traditional preemption area, as many others are in Oregon. It's better, because we are, we cross state lines, but we also cross county lines and city lines pretty regularly. It could get, pretty complicated were we to have different laws in different cities and counties for guns and other weapons and ammunition. I'm not aware that we're having any particular discussions, but again, keep in mind, folks, that my office represents state government, right? So we have over 100 lawyers who represent state agencies. At any given time, there may be a question before us, before one of my attorneys, that I'm not aware is before us, and I couldn't tell you about it even if I did know about it, because it would be attorney-client privilege, right? So some of these questions you're asking me, and you say, are you aware of? I apologize if I'm not. It may actually be that we are looking at some of these issues, but that I wouldn't be in a position to discuss them. Anytime there's a state government agency, board, commission, we advise that agency. So I'm sure that it will come to us if it gets to that point where we need to weigh in on it. And as for I really haven't developed my own opinion about it. I think it would have to do with a legal opinion and not necessarily a personal opinion.
Thank you. Take a question from the mic.
Kurt Wavering, member. Oregon is one of only 2 states in the country which does not require unanimous jury votes on felony charges. And I wonder what your position is on that and how that can be changed.
I think it's about time to be changed. And you know, I've never said that publicly, so thank you for the question. I was a judge, as I think you know from the introduction, right here in this county for 16 years, and then I was on the Court of Appeals for 6 years. And I'm kind of embarrassed, to be honest, that I really haven't, you know, I never gave it more thought, really, and worked on it before I ended my judicial career. So I think maybe the time has come for me to become an activist in this regard, particularly given the history of where it came from, which I wasn't aware of, actually, until recently. At the same time, I will say this. As a judge, having presided over hundreds, if not thousands, of jury trials, I never, ever felt that a jury made the wrong decision. So perhaps that's why I didn't take it on, because I have a great deal of confidence in juries, and I hope that we continue to have a robust jury system, both at the civil and criminal levels in the state. It's very important. And thank you for serving as jurors. We really appreciate it. I love jurors, because they're you, they're people, they're voters.
Question from Twitter. Some advocates have suggested that one approach to address police misconduct is to establish a special prosecutor's office at the state level to investigate and prosecute cases where police officers kill civilians. What role do you see for your office in ensuring accountable, credible, and transparent investigations into officer-involved shootings?
Thank you for that question. That is an issue that has been addressed, at least to some degree, at the legislature. There was a proposal a couple of sessions ago for my office to have that role. We did not take a position on whether we supported it or opposed it. We would certainly be willing to take it on if it was determined that this was the place for those investigations to take place. I will say I would need substantial additional resources to do that. I have a very small criminal division. Some people think that we have all the resources in the world because we do take on, and I told you that we will, if requested, we will assist district attorneys and law enforcement. And on these cases that you've mentioned, which are some of the most absolute critical, important cases that we have in the state, if I am asked to handle a matter by a district attorney, I absolutely will make sure that my office does take that on. And that has happened. There have been situations where a DA will just simply feel that there's, you know, a conflict of interest, or may swap with another DA rather than coming to my office. So there are other ways to assure that there's not that kind of sense of it being a little bit too close to home, where the investigative authority is, say, working directly with the sheriff or the law or the other law enforcement officer who's accused. So, I think I'm sounding a little wishy-washy on this one, but it's only because I don't think that it's up to me to make that request. If that's what the people want, and if that's what the legislature decides upon, and the district attorneys agree that it's appropriate, we still have to go to a county grand jury to charge a case. We don't have our own state grand jury, and I don't think anybody wants that. So there's a lot of factors to take into consideration. I'm open to talking about it.
Take a question from the mic.
Hi, Bobby Regan, City Club member. You were the first female state attorney general for Oregon.
Yes.
Do you know how many other states have female attorney generals? And in your opinion, how would things be different in this country if our state attorney generals were 50-50 male, female? Second part of the question is, I'm just curious also how many are people of color?
Yes. Oh, my goodness. Well, what a great softball question. I don't know if it's the last question, but I love it. There aren't very many women attorneys, just state attorneys general. There's only about 10 or 11 of us, I think. We just added one more in New York, Barbara Underwood, who's quite wonderful. And of those, about half of us are Democrats and half of us are Republicans. We just got our first Sikh attorney general, which is really fantastic, in New Jersey. We have a black attorney general and Haitian American attorney general in Washington, D.C. We have an African-American Attorney General in Indiana. We have a Hispanic Attorney General in New Mexico, Hector Balderas. We have a Hispanic Attorney General in California, Javier Becerra. So we have quite we have a fair number, I'm not going to say quite a few, a fair number of minorities. We also have quite a number of wonderful candidates. This is a big year for state attorneys general. There's 35 races. Last year there was one. Mine is not one of them, which is nice. But I will say that I think it makes a difference, it's kind of hard to totally, wrap your arms around exactly what it is that makes that difference. But I think it's true with the judiciary. It's true with district attorneys, state attorneys. It's true with just about every field that you could imagine. I happen to be in the legal field, so I'm focused more in that area. I was one of the first women to, really, the first classes where there was a significant number of women in law school back in the 1970s. So to me, it's just kind of a no-brainer that it's important to have a variety of diverse viewpoints that stem not only from who you are and what you look like, but from the background that you bring, from your geographic background, from your national and ethnic identity. So as far as state attorneys general go, I kind of make the joke a little bit that they think of us as the top cop, and when we run for office, you're running for the top cop. I kind of think of myself as the mother bear, the protector of consumers and the most vulnerable. And maybe that's a little bit more of a kind of a feminine thing, but you could be the daddy bear too, I suppose. So it's not so much that we have to have equal numbers, but I think that it's important to have greater numbers, and we clearly have a long way to go. And I'm actually involved in an initiative right now to try to move that along. So thanks for the question. And by the way, it's a great honor to be the first woman, but it would really be a tragedy if I were the last. So I'm trying to do a really good job. So there'll be more of us.
So we are out of time for the day, so we will end with that softball question. And thank you so much. Let's give Ellen a round of applause.
Thank you so much for having me. Thank you.
I would also like to say a special thank you to Steve Novick for producing today's program and all of the hard work of staff and volunteers. We are adjourned for the day. Thank you so much.